Michael Oher, the inspiration for the award-winning movie The Blind Side, now claims the movie was all a lie. In a lawsuit, Oher claims Sean and Leanne Tuohy never actually adopted him. Instead, the couple allegedly tricked him into a conservatorship that reportedly included signing away the legal authority to use his name in business deals after he turned 18. Oher, who was drafted 23rd overall by the Ravens back in 2009, is now seeking to end the conservatorship at age 37. So with cases like Michael Oher's, Britney Spears, and Amanda Bynes, conservatorship has just been put in the spotlight a lot lately.
Yeah, joining us now is Nina Cohn, a law professor at Syracuse. Professor Cohn, thank you so much for joining us this morning. So break down exactly what is a conservatorship, because a lot of people have been hearing this word, not quite sure of what it means.
Sure. So conservatorship is a legal process where a court appoints somebody to make decisions for a person who the court's found can't make informed decisions for themselves and is at risk because of that. Some states like Texas will call it guardianship.
Gotcha. You know, we mentioned some of the public figures with conservatorships. It's gotten a lot of criticism, though. So talk about some of the pros and cons of having one.
Sure. So conservatorship can provide a way of making sure that there's somebody to make decisions for a person who's really at risk because cognitively they're not able to do that, even with support. And the person hasn't done the type of advanced planning we attorneys would recommend to make sure that there's an agent in place to make decisions. But it's a really drastic remedy, and it's one that you should only be using as a very, very last resort when you can't meet a person's needs any other way. Because what you're doing is you're removing a person's right to make even the most fundamental decisions often about their own lives.
Yeah, you recently were quoted in an article. You're saying that this situation can open up that person for abuse and exploitation. Why is that?
Well, because the people appointed as conservator sometimes don't understand their role. And they may, even if they're acting in good faith, mismanage or make decisions that don't respect the person's wishes and values. And there are times, unfortunately, where the appointee may use the power that the court has granted for their own benefit. And that's why court supervision and good supervision, the type of supervision, alas, we often don't see, is so very important here.
Right. And are there different types of conservatorships, and do they vary from state to state?
Sure. There's two major varieties here. There's appointments that are designed to create somebody who can make personal decisions for the individual, things like health care or where they live. And then there's an appointment over finances. Either of these can either be broad, sometimes we call that plenary, so you're granting all the powers available under state law, or they can be limited. They can be tailored to the specific person's needs. The reality is probably every, or almost every, conservatorship in the United States should be limited if one's going to be imposed, because most people can make a decision about something, right? Even if it's just about what to eat or what to wear. Unfortunately, most conservatorships in this country are plenary.